Call to order the Information Technology Committee meeting. First item.
First item, call to order, roll call, and agenda changes. Roll call. Bruce Wolf, absent. Member Josh Wolf.
Present.
Member Josh Wolf, present. Chair Yankee.
Present.
Chair Yankee, present. We have a quorum.
And we'll just note that Member LaHood and Member Hinsey are here as well, sitting in.
Item number 2, public comment. Item number 2, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Hello?
You are present. Anonymous caller?
Yes, all right. I have 3 minutes, correct?
Yes.
All right. So this is Anonymous again from case 19047. I wanted to thank you for your findings in 19047, and I look forward to the order of determination for non-property and ICS calendars. I was reviewing your old minutes from this committee, and you had previously considered making a database of the case law of this task force, and I urge you to retake up that matter. And for a few technology issues that are unrelated to metadata, inconsistency is a repeated issue I've encountered in my wide-ranging requests to numerous agencies. Each does things a different way. Why is this? So many of the tasks of redacting safely and producing records consistently to everyone can be solved at least partially through the use of improved automation. Why does Public Works release all records publicly through Next Request open to the internet, while the Department of Technology defaults to the opposite? Why do the city attorneys and mayor's offices not even have a web portal to publish all their records? If you do the work to give me 2,000 pages of records related to the Adachi and Karmati incidents, why not give that work output to the world? By law, it's no secret. It's a public record. Now, anyone who cares about government transparency is well aware that the city could use its powers under Proposition B to gut the Sunshine Ordinance, and we are all hyper-vigilant about those issues. But it could also use that Prop B power to prioritize and fund what is known in the corporate tech world as privacy engineering, which would allow the city to automatically redact certain kinds of records and to do so in a more efficient manner. And I urge this committee and the task force to make such recommendations about the technology that the city could use to release public records more efficiently and safely. Thank you.
Okay. Any other public comment? Okay, seeing none.
Through the chair?
Yes.
I just wanted to inform our anonymous commenter that many of the things that you described have been discussed in both this committee and other committees, as well as the group looking to put forward a new revised Sunshine Ordinance. And the issue with the database pertains to not only the time and bandwidth for us to make forward on the work, but also budgetary constraints. So we are moving forward with all earnestness, but it is a process. Thank you.
Next item.
Excuse me. Item number 3, file number 19092, complaint filed by Justin Barker against the San Francisco Zoo for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and/or complete manner. Is this the first appearance of this particular issue?
I believe so, yes.
Okay.
That's my understanding. So the complainant's here, but anyone from the zoo? Looks like no one from the zoo.
Okay, start the timer.
So,
You ready, sir?
okay.
Good evening. Last month, actually August 7th, this committee found that the San Francisco Zoo had violated the Administrative Code, Section 67.21, 6727, California Government Code 6253, and then the California Business and Professions Code 4857. So you all have kind of made a decision on that case, and there was a determination ordered. So, and that was the number 19048. So the day after that decision was made, I sent a larger request for more information. When I had initially sent a request for information to the zoo, I wasn't really expecting them to not hand over documents, so I'd only asked for a few documents. This specific request for documents was just an expansion of that original request. What's really happened since that determination has come to light and been served to the zoo. The zoo showed up to the the Joint Zoo Commission and said that they don't believe that your determination was accurate, that the zoo is protected by attorney-client communication privileges and are personal and patient confidentiality, and refused to hand over documents. And they, sent a letter to Cheryl saying that my requests were far-reaching, overly burdensome, and intrusive. So the last meeting, compliance meeting, that crew found that they're forwarding that original complaint to the wider task force to decide whether it goes to the ethics committee or to the city attorney. And so I'm here, it's the same matter. It's essentially the same request. And we kind of know where the zoo stands. They haven't shown up to the last two meetings, and they just don't believe. They think that they're above the law and don't need to follow through on the law. So I don't really know if it's possible to combine these two matters because that one's already kind of moved through a bunch of hearings and have been heard. So I'm just here to see what my options are. It's essentially just a wider request for information based on what I've learned that the zoo is just refusing to hand it over. So I'm hoping you guys could help.
To the chair.
Sure.
Mr. Barker, let me ask a couple of questions for you real fast. So we have a response to the records request that was delivered to our staff. What was the response that you received?
I'd only received one. I didn't receive any response to this request.
And so you filed an immediate disclosure request, which honestly, from the face of it, is probably more of a traditional Public Records Act, but it's fine.
Yeah.
But had they responded within 24 hours saying that they need 10 days, I would have totally personally understood why
Of course.
This is a lot to turn over in a day. But I'm just trying to understand that they did not, in fact, respond within 24 hours in any way of your request.
Yeah, they just stopped responding to any requests that I make.
And then you spoke of interest in combining the two cases. I don't really know the feasibility of that, but the initial case established the zoo's perspective that this wasn't a public record, and we ruled differently. At this point, we have essentially the zoo ghosting you, for lack of a better word. And I think that potentially opens up a different sort of type of violation than we were looking at previously. And so for that reason, it doesn't seem savvy to combine them, even if we could, from where I'm at. And I don't know how my colleagues feel.
Other input?
I mean, I don't think we should combine them, although since we're asking the same participants to respond, I think if we don't already have too many items on the upcoming agenda, including these participants, I think we should put them on the same agenda so that to save their time and also because it's easier for us, since they are related, I think to process the information if we're hearing them back to back.
I think that's a good point. I think it'd be no reason to make you come to two meetings if we don't have to do that.
Cheryl, what is the status of Mr. Barker's other complaint? Because I don't believe I think it's gone through the full task force.
Task force and an order of determination was issued.
Right. So it's now at the committee level. This one needs
No,
to.
it's going back to the task force. It was already at the committee level, and we kicked it back up.
We went to CAC and it's going back.
right?
That's correct.
Okay.
Or did we already,
wait, so
have I missed a meeting?
it went to the complaint committee, then it went to the full task force, then it went to CAC, and CAC is sending it back to the full task force?
For a willful violation?
Oh, you weren't here. Hang on.
Let's see.
Is that your understanding, Mr. Barker?
Yeah, essentially they want to send it to the full task force because they kind of said there was two options that we either, like I said, either going towards it be going to the ethics committee or going to the city attorney. And they didn't want to make that decision, and they wanted the full task force to make that decision.
I think you mean district attorney, not city attorney.
District attorney, correct.
Yeah, so I think it does definitely make sense to calendar these together. It seems like there's some likelihood that the zoo will not appear at that hearing based on their past performance. So it'll consolidate and figure out how we want to deal with that by putting them together. And it sounds like everyone's...
Yeah, it's correct. It was not on the October agenda. So the last time you were before us, it was at the CIC
Yeah,
hearing.
September 24th,
Yeah.
I found it, yeah. On that one, yes, it looks like you guys referred the matter, back to the full task force with the recommendation they forward the matter to the Ethics Commission and
Yeah,
District
and I
Attorney's
think Victor
Office.
and I are in the process of drafting those letters now. I mean, I know he started, and I've been looking at them, but I haven't really put my fingers into it yet.
And now, Mr. Barker, obviously what you would like to do with these orders of determination and so forth is entirely your business, but I'm curious, based on your plans, if a particular course of action makes more sense than others between the district attorney or, some people are looking to prepare a lawsuit, other people are looking to gain more attention, more publicity. So is there a course of action that you would like us to consider?
The course of action, I'd just like them to hand over the records. And I think that there an argument can be made that if it goes to the ethics committee and the ethics committee finds that they're in willful violation, that is doesn't look great on the zoo. But I'm not really sure, from my experience, the zoo really cares about that. So I think that whatever is most likely to have the biggest impact for them to actually take action, I think this whole process has really illustrated how irresponsible management is. This zoo is run by a lawyer, and she's willfully breaking the law, and I just find that to be sad and ironic. So originally I had asked it to go towards to the ethics committee, but I think that the district attorney might be...
Yeah, I think part of the concern I have is there's actually a contract involved in here as well. So, between the zoo and the city. And so if the zoo is not fulfilling the terms of the contract, that might be something that the DA perhaps...
Isn't this a little premature?
This is probably a little premature, yeah.
I don't
I think
we
it's
need
definitely
to try to
premature.
make this decision now. I think what we need to decide is
we
that
don't
this
have a place to make that decision.
Exactly.
I was only asking him if he had a preferred method so that he could prepare that argument for the upcoming meeting.
Okay.
It would seem to me logically, if there's room on the agenda with the other item coming up, since we are inviting both parties, and we don't know whether the zoo will or won't show up, but for the convenience of all participants, if we know that we're asking two parties to show up for two separate things, if we could put them on the same agenda, that would possibly increase the chances of both parties showing up.
Yeah, I think we're all in complete consensus on that. Chair, where are you at on this item?
Not sure there's much more to say on this one. I mean, I think it's pretty obvious that they're not here. So
I
that's
just want to remind the
concerning as well.
committee that you can only have 2 agenda items per complainant on any agenda. So if there's more
Per
than that, then
complainant,
we have to consider that. There's just 2?
Does Mr. Barker have more than 2 complaints?
Do you?
Just these two.
No, and I'm not sure I would,
2.
the original one's even in the complaint stage. I mean, the initial one's
The original
coming back.
one is
It's
pretty
not,
much concluded.
that's coming back
with
from
an
the
OD.
CAC.
Well,
so-
either way, there's only
Yeah,
2.
either way, there's only 2, so,
There's only 2, okay.
yeah.
So I'd like to make a motion to find jurisdiction and refer this to the full task force.
Second.
Any public comment? Seeing no public comment? Call the roll.
Thank you.
Oh, call the
Oh.
roll.
Just, I don't know if we want to put as part of the motion to try to agendize it the same as the,
I'm not sure that needs to be part of the motion,
Okay.
or that's just
That's a
been
practical
instructed to
consideration.
Cheryl already.
okay,
Okay, so we want to forward to task force, find jurisdiction in the records of public.
yeah,
That's what we're
that's the
finding.
motion.
Right, and then there was we want to schedule them the same time, but I don't think that needs to be part of the motion.
Yeah, okay, and so you made the motion, Josh?
Yes.
Okay.
And I second.
Mm-hmm.
Well, I don't know what should I say.
Handle that.
Well,
And you only have
I suppose
Two
one, Bruce Wolf isn't coming, so I guess
Yeah, you only
one
have
could
two.
technically fill in for,
Are we
For
only
him.
allowed to have 3 voting people?
that the,
I believe that's,
okay. so-
Okay.
only the members who are listed are part of the
Okay,
IT
so-
committee.
Fiona, it's all yours.
Okay,
all right,
so
second.
I guess Fiona will be the fill-in for.
I mean,
Fill in.
I think we actually made a mistake by listing members of the IT committee because in the bylaws it's defined as an ad hoc committee.
Yeah. And I was under the impression that whoever wanted to participate could participate.
Okay,
How about this? Could I vote? And
If
if
it's-
if it's disallowed, you can strike mine.
There we go.
okay.
That sounds safe.
There we go.
All right,
That sounds
but if
safe,
Fiona
yes.
is second.
Yes.
All right, let's call the roll. Okay, Member Wolf.
Aye.
Member Wolf, aye. Member Hinsey.
Aye.
Member Hinsey, aye. Member LaHood.
Aye.
Member LaHood, aye. Chair Yankee.
Aye.
Chair Yankee, aye. The motion passes to send to the full task force. Okay,
Thank you.
very much. Item number 4.
Yep. Item number 4.
Okay. Caller, are you still available?
Yep. Can you hear me?
Yes. Okay, we're about to call your item. Item number 4, file number 19095, complaint filed by Anonymous against Dennis Herrera and the Office of the City Attorney for allegedly violating Administrative Code Sections 6721, 25, 26, and 27 by failing to respond to a public records request in a timely and/or complete manner.
And we have a respondent here as well, so we'd go ahead and get started. Anonymous?
Hello?
All right.
Okay, you can get started.
Hello. Good evening, Chair and members of the committee. Anonymous once again here. And there's no PowerPoint for this one, but if you could flip to page 41, which is page 5 of your PDF, this gives you the details of what I requested. There are 2 parts to this request. The first was a catalog of all of the city attorney's enterprise systems. Now, enterprise system is a defined term in the CPRA, Government Code 6270.5. However, this portion of the complaint is being withdrawn because it would duplicate the issues in case 19094 versus the Department of Technology, which is already being docketed to the full task force. I want to be clear, this is not a concession that the city attorney's catalog is correct. If I win the DT case, I will probably bring back a new complaint against the city attorney. Now, the second part of this request, which we are in active negotiations with the city attorney just these last few days, is for the internal memos, directives, orders, emails, and change logs of the annual updates to this catalog. And they are withholding all of these responsive records based on the attorney-client and work product privilege. Now, the attorney-client privilege applies to confidential legal advice between an attorney and their client. But who is the client here? This is the city attorney's own catalog updates. And the work product privilege also does not apply. The privilege is defined in section 2018.030 of the California Code of Civil Procedure. It, of course, applies to attorneys' output, not the output of, for example, IT staff. I'm going to read you a quote from the California State Bar website. The statute does not define work product. Courts have considered the issue on a case-by-case basis and have generally concluded that only derivative or interpretive material, that is, quote, material created by or derived from an attorney's work reflecting the attorney's evaluation of the law or facts, end quote, qualifies as work product. Non-derivative material, such as, quote, the identity and location of physical evidence or witnesses, end quote, does not constitute work product. And that ends the statement from the California State Bar. Now, the city has failed to distinguish which records are exempt under which privilege, so I'm not really sure which is which. However, if any of those records were written by IT staff, which I would assume some of these are, or if they were written by attorneys but are not an interpretation of the law or advice to the client, they should not be privileged under either attorney-client or work product privilege. And that is the only remaining issue in this case. So I ask that you find jurisdiction, that the records are public, and refer this up to the full task force. There are no computer science or metadata issues to split off here. This is solely a legal question about the extent of the attorney-client and work product. Thank you.
Thank you, Anonymous. Then any other speakers on behalf of the complainant? Seeing none, the respondent.
Good evening, task force members. John Cote. I'm the communications director for the City Attorney's Office. I'd first refer you to our written response in this matter, and then separately, as to the question of privilege, we responded to this anonymous complainer recently, where we indicated that his second request, which sought records evidencing our compliance with Section 6721.5, and in that regard, we invoked privilege in response to that request because the request encompasses confidential communications concerning our legal interpretation of that section of the law. And that's our position. I'm happy to answer any questions you may have.
Any speakers on behalf of the respondent? Seeing none. Members?
To the chair, I've got a question for the representative from the City Attorney's Office. So we heard the complainant describe both these enterprise records as well as I think they referred to them as catalogs. Can you in layman's terms explain what he's asking for?
I'm not fully up to speed on this issue. In fact, I thought we were going to be discussing separate metadata issues at this committee hearing today, so I can't provide further insight at this point.
That makes two of us. All right.
I think I can actually provide a little insight on this one. So there was a bill a few years ago that directed local agencies to develop a list of their enterprise software systems and make it publicly available. So any type of enterprise software system. This is kind of an odd part of the Public Records Act where it's actually directing public agencies to create a document rather than speaking necessarily to the public nature of a pre-existing document.
Right. That's the first part of Anonymous's request.
So I think the second part, is just asking for the
Updates
discussions
to
that led to the creation of that, like the background back and forth to how they developed
Through
that
the
catalog.
Through the chair, you mind if I ask our complainant?
Sure.
Anonymous, can you explain what these catalogs are and just in layman's terms describe what you would like to have received from your request?
Sure. I want to be clear. I am actually withdrawing the complaint about the first part, which is the actual catalog. I'm not saying that what they did is correct. I'm just saying I don't need to process two cases against the city for the same exact thing. 19094 is already doing that. Now, to answer your question, this is basically a spreadsheet of names, like there's some brand name they use to docket their cases in the city attorney's office, and it explains what they do and who the vendor is and what kind of documents are stored. The city attorney's office has a catalog of exactly 3 rows, and I had originally alleged, and I still believe, that they should have Microsoft Outlook, Microsoft Exchange, things that are both in the layman's terms, the word, quote, enterprise systems, but also, as I argued in the file, meet the legal definition, which is a very complicated definition for this term called enterprise system. But again, I'm withdrawing that part of the complaint. All I want is the second part, which they are claiming is privileged, which are the memos, directives, orders, emails, change logs of their annual updates, which is also statutorily required.
And so the city attorney has argued that that all of the following memos, directives, orders, emails, and the change logs are all not public documents?
Are you saying, is that what they represented to me, or was that a question to them? Sorry.
That's a question to you first, and then I'll circle back to them.
Sure. Certainly. So I'm just going to read you the quote that they have given me. I haven't had a chance to enter this into the record, but I will as soon as this meeting is over. This is the quote from Elizabeth Coolbritt, the paralegal for the city attorney's office. Quote, finally, we decline to produce documents responsive to the second part of your request as they are exempt from disclosure under the attorney-client privilege and work product privilege, and I have omitted the citations.
And just so I understand what change, so I can kind of understand where their argument might be, and I'm not giving it weight. I'm just saying that I understand where the argument around memos, directives, orders, and emails could relate to attorney-client privilege in theory. Can you explain what change logs are? I think I know, but I want to hear from you.
Certainly. So when you have a spreadsheet, you alluded to this in case 19047, but when you have a spreadsheet, and let's say you're either Microsoft Office or Google Spreadsheet, as you change that spreadsheet, in the record will be stored all the deltas and differences as you go along. Or if you use a more formal system, you'll actually submit a ticket each time you change a particular record. I don't know if they have any of those, but if they do, I think those are public records as well.
But and correct me if I'm wrong, but essentially the change log of a catalog of enterprise systems would be like, we went from Office 6.1 to 6.2 on this date. Is that essentially what a change log of the catalog of enterprise systems would look like?
No, not necessarily, because they're not required to update the catalog in real time as they purchase or decommission systems. They're only required to do it as the statute says, thereafter shall update the catalog annually. So maybe they updated a lot of things, and then, 12 months later, they make a single delta or change to that spreadsheet and add or remove things. Does that make sense?
Yeah, that makes complete sense. And then if I could speak to the city attorney rep again. And I understand you may not be prepared to answer this question, but it needs to be asked. Is the city attorney's representation that the change logs are also not public information?
I'm not prepared to discuss that point at
Got
this
it.
time.
Sure. And then a question for Cheryl. It seems like this is actually more of a legal question than a technology question, and I'm curious how did it end up in IT? Does it seem like it?
I wasn't.
You were
part of
gone.
that.
Got it.
I think that the ones that were originally going to go to CAC, just the regularly
Yeah,
scheduled
this is-
complaints.
Yeah.
this is just-
Should this go to
that
the
got
task
canceled,
force, and that's why we're
We're just
evaluating.
hearing
Yeah,
complaints.
and Victor.
I see. So this is more about hearing a complaint than our IT.
Yeah,
Correct.
yeah. I
Yeah.
think just the last item is really.
We were just
yeah,
the next committee meeting.
Yeah.
Yeah,
So
and
that-
Victor did note that this was sort of about ish metadata, but
Yeah, perhaps
Yeah.
he was
in
combining.
the realm of
Yeah.
it,
Yeah.
maybe.
Probably discuss this with Bruce Wolf.
Sure. Yeah, that's fine. It seems to me, from where I sit, that there's some legal questions that are going to be super helpful for our city attorney representative to help us navigate. Of course, he's only there for our full meetings anyhow. And so given all those pieces, I don't see a reason not to find jurisdiction and refer it to the full task force. But I'm curious if anyone sees more to unpack in the interim.
Not at this point.
nope.
Anyone want to make that motion?
Oh, you're making the motion. Who will second?
What?
Are you
You
making?
make-
Okay,
Motion.
sure. I'll make that motion.
Second.
Any public comment on the motion? Seeing none? Go ahead and call the roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Yankee?
Aye.
Chair Yankee, aye. The motion to send to the full task force passes.
And through the chair?
Yes.
Anonymous, do you plan to stick around on the phone to make a potential public comment on this last item?
Yeah, I also submitted a white paper in your packet about the next item, correct?
Yeah, I was just confirming that I thought you were going to stay on the phone, but I just wanted to get clarity.
Oh, okay, sure. Yep, I'm sticking around. Yep.
Okay. Next item?
Item number 5, file number 19105, hearing, review of metadata and what portion can be disclosed as public records, possible security risks, and other related issues.
Want to start with public comment on this? Or did we want
You
to?
want to do 2 rounds of public comment?
Well, it's a hearing, so
But if there's a motion that comes out, we'd have a second. But yeah, we can do that.
maybe do that just to hear from anyone who would like to comment on this item as a starting point. I know Anonymous did, so maybe we could start there. So, Anonymous, did you want to speak to this item? Start with you.
Sure. Okay. So, good evening again. So I know, the initial reason that we are here is because case 19044 was referred here to the intricacies of email header and metadata. I would like to point you to page 83 of the PDF for item 5. And this is a white paper I have produced for the task force regarding various issues around electronic public records release policy. I don't know if any of you had a chance to read it. The primary purpose here, and if you flip to page 85, is I want to make sure we don't lose the forest for the trees here. We're not here, at least I'm not disputing the city's individual redaction of individual headers. The problem here is that the mayor and the supervisor of records take the position that they can physically print and scan records back in on paper, even though they're electronic records. And this causes a loss of not just metadata, but the body of files. And the position of most other city agencies is that they can convert directly to PDF, which causes loss of metadata and occasionally of the body. Now, in your decision in case 19047, you found that they must also generate easily generated non-PDF formats. But the problem here is that between that line that the task force has drawn and the line I have shown you here as A, there's a lot of other information that is absolutely public, but there's nothing to do with information security that the city won't release. That includes images, hyperlinks, and other rich formatting on the face of the record, standardized data structures and names of headers and fields, and the version of those formats, which is not the same as the version of the app producing it. And most egregiously, the government email addresses in the to, from, CC, BCC sender, and other similar headers, the creation, modification timestamps, and the author identity and versions of a document. Now, the city miscites multiple laws to you in order to make this argument. And I would ask that you go through my 10-step legal analysis, which shows you the full context of each of the laws that they are citing. Reasonable segregation of information is not required when copying a record. It is only required when inspecting a record in person. In copies, minimum withholding is required under the Sunshine Ordinance. And you already identified one of these miscitations in 6721L. This inseparably intertwined only applies to visually looking at a computer monitor in City Hall. Now, they've also cited 6253.9F, which if you read it does not actually prohibit metadata disclosure, and the important one, Government Code 6254.19. Now, if you look at that, and that is going to be on page 96 of the PDF, read the full paragraph, and I would ask one of you to read that into the record. It is possible that some records are information security records, but email is not. Email is a, quote, record stored within an information technology system, and Government Code 6254.19 in fact says it cannot even limit the disclosure of such records. Now, it is possible that some of the headers inside an email may reasonably be an information security record, and reasonable people will defer, and that's why you have, I think, like 4 cybersecurity chiefs here from the city who will hopefully help you understand that. Now, they've finally made another argument, which is that if the city employee doesn't physically type in information into a computer, that's not a public record. I think the word they use is in the course and scope of their employment. But if you follow that argument, so many important records will no longer be public records. Police body cam footage, video camera recordings, they weren't made by a human being. Emails from outside the city, they weren't written by city employees. Financial, tax, and accounting records. Well, most of a financial record is computer generated based on the inputs from the employees or gathered automatically from bank systems. Or even simple things like filled out forms. Remember, the form template wasn't typed in by a city employee. In the modern world, computers generate almost all portions of many records automatically. But a city employee operates the computer directly or indirectly to perform those actions and generate the record. Just like a human being directs a camera to record footage, even though the human being does not draw every frame of footage with a paintbrush, we must interpret the public records laws broadly, and native electronic files and their metadata must be disclosed. Now, the rest of this report actually just goes through various examples of how you can or cannot produce electronic files, my opinion on whether those are legal or not, and also various examples of data and metadata that may exist in a file, no matter how you produce it, whether you produce it in native electronic format or in PDF format, and my argument on whether those may or may not be public. I've also ended with an explanation of certain information security terms like spoofing and phishing. I don't think the city has done a good job previously explaining those, but hopefully you have some experts who can help you with that as well. Thank you.
Thank you, Anonymous. Any other public comment before we start discussions? Okay, seeing none.
Hank, are you getting up?
So
Wait.
Is he public now?
that's
Yeah.
what I'm discussing is we basically heard from Anonymous as if they were a hearing member. We, I think, had 5 minutes of time. So I think we should actually look at this as the people in the room are hearing members and not public.
Right.
So all of the people in the room are city employees who we can hear from as members of the hearing.
May I make an order point? Sorry.
You want to put
Sure.
on?
Yeah.
I believe in a normal hearing, I know you have many city employees there. I think there's a rule that says the total time for the person who wants to make a record public should be the same as for the city. I would just ask that you give me a chance to respond because I know they have a lot of people there. So thanks.
Through the chair?
Yeah.
This is an informational hearing as opposed to a complaint hearing. So,
Yeah.
Everybody gets 5 minutes.
Right.
yeah.
Yeah.
But we can certainly circle back to hear from you in the tail end at the point that we make a motion.
If we do, yeah.
Well, we can always make a motion to table it, which will create.
That's true.
Ready?
So go ahead. I'm sorry.
Actually, if through the clerk, if I could get access to the overhead projector. So good evening again, task force members. John Cote, I'm the communications director for the city attorney's office. First, I'd just like to reiterate a few points for the record. What we were talking about here is email metadata. This is machine language that reflects the inner workings of our computer systems. It is not even visible to average users inside the city, except for IT staff and those who are trained on how to find it. Now, we're not aware of any case law that requires us to produce email metadata to someone requesting it under the Public Records Act or the Sunshine Ordinance. I'd like to refer you to page 102 of the city's Good Government Guide, which I have here on the overhead, and I've highlighted the relevant section, which, as you'll see, reads, there is no evidence that either the Public Records Act or the Sunshine Ordinance was intended to require public entities to search and then review and possibly redact metadata in electronic records. Now, I know the last time that this issue was before this body, the full task force, Chair Wolf pointed to a guide produced by the League of California Cities. And that guide, titled The People's Business, included what is described in it as a practice tip that read, agencies that receive requests for metadata or requests for records that include metadata should treat the requests the same way they treat all other requests for electronic information and disclose non-exempt metadata. Now, first, this statement has to be placed in context. It is not a statement of law, what's included in the League of California Cities Guide, and it is not even legal advice. In fact, that guide itself on page 2, this is the guide in question.
Microphone.
Here's the relevant section where it indicates this publication is provided for general information only. It is not offered or intended as legal advice. Readers should seek the advice of an attorney when confronted with legal issues, and attorneys should perform an independent evaluation of the issues raised in these materials. So that's exactly what we've done here. We consulted with our attorneys. It is their determination that there is no applicable case law that requires metadata to be turned over. So as I noted in the Good Government Guide, again, there's no evidence that either the Public Records Act or the Sunshine Ordinance was intended to require public entities to search and then review and possibly redact metadata. So as we noted, the language in the California League of Cities pamphlet is a self-described practice tip. It's not legal guidance. Even as a practice tip, it says should, not shall, not must, not is required to. So our position is not that metadata must never be disclosed. It's that the type of email metadata that this anonymous complainer is requesting is not required to be disclosed. Now, on occasion, our office has encouraged departments to disclose certain types of metadata, for example, regarding calculations on Excel spreadsheets. Now, that's consistent with the view that disclosure of all metadata is not required. While we're unaware of any requirement to disclose metadata, there are clearly pre-existing exemptions to disclosing metadata that apply to other records, other electronic records that would also apply to metadata. As you know, the Public Records Act provides two different exemptions that are relevant to electronic records, 6253.9F and 6254.19. I'm happy to read those into the record if you don't have them handy. But the point here is that email metadata can disclose or lead to discovery of all kinds of sensitive information. You've already had the anonymous complainer noting during our previous session that security risks are posed by disclosing some email headers, and he's reiterated that point tonight. Are we limited by the 5 minutes? Okay. So additionally, I just want to make the point that producing, reviewing, and redacting metadata is a labor-intensive and it requires technical expertise. So producing this information in a format requires exhaustive and technical judgment calls to be made regarding voluminous redactions, and it's not required under the CPRA or the Sunshine Ordinance.
Thank you.
Happy to answer any questions you may have.
Any other speakers?
Good evening, Chair Yankee, members of the task force. I'm Hank Heckel. I'm the compliance officer in the Office of the Mayor. I'd like to respond to some of the issues that the Technology Committee is studying tonight, as well as respond to some of the points that Anonymous raised. Referring back to Anonymous's comment about the referral to this committee, there was the referral on the email issues involving the City Attorney's Office under File 19044. I would also note at the hearing on the complaint 19047 against the Mayor's Office, I did ask the task force to refer the portions of that complaint that dealt with metadata as it relates to that file to this committee, and that was agreed to. So that complaint specifically addressed calendar entries, Outlook calendars, and associated formats and metadata. Providing extensive metadata, including in response to requests for emails and calendar entries, poses a significant security risk to the city in terms of data breaches, phishing, and spoofing, and is not required under the Sunshine Ordinance or CPRA. The types of risks posed by production of metadata has been discussed extensively in the prior hearings, and cautionary examples in the real world regarding hacks of municipal systems are abundant. The Asian Art Museum right here in San Francisco was recently hacked, as well as other cities in the Bay Area, Atlanta, and Baltimore. Others here, including Cybersecurity Chief Michael Maxman, can address some of these risks in more detail if the committee would like today. Anonymous recently conceded that various types of metadata may, in fact, pose a security risk that will be addressed, that has been addressed by Mr. Cote. As Mr. Cote said, there is no definitive authority in the CPRA or the Sunshine Ordinance or state case law on whether and to what extent metadata should be provided in response to a public records request. Mr. Cote covered some of the applicable provisions in the CPRA. I'd like to point out an applicable provision, or at least one that's instructive in the Sunshine Ordinance. That's section 67.21L, which Anonymous alluded to. This is the provision that refers to providing documents in a format that is, quote, easily generated by the department. This section is important for a number of reasons, but I'd like to highlight ones related to that clause in particular. It highlights an important issue concerning the security risks and also the burdens and practical limitations on the city's ability to provide records in various formats and with various data. In order to provide a record in certain formats that include all associated metadata, the city must engage in a highly complex, specialized and technical review and consultation with not just attorneys but also with IT professionals. I'll give you an example. Anonymous has sought Outlook calendar information for various officials in native, quote, .ics formats with all associated metadata. Some of these he may concede pose a data security risk. I recently tried to perform this process in my own calendar in consultation with a city IT professional. It involved several steps to produce the format and then an extensive review of potentially dozens of lines of metadata by IT to vet it for security risks. I'll just quickly go through the steps. First, the entry must be opened as an ICS file. Second, the file must be saved as an ICS file to the hard drive. To save it directly as a TXT file does not generate the metadata sought, as has been previously asserted. Third, the file must be opened in Notepad to generate a TXT file, which will include the metadata for the file. Fourth, and this is critical, the file must be converted into a format in which redactions can be made, such as Adobe PDF. Anonymous offered an example of an ICS calendar.
Wrap it up.
Okay, I think he may address it. I have copies. If I could offer those into the record. There's over 44 lines of metadata that would need to be reviewed in producing such a document.
Thank you.
Through the chair?
Yes.
How many copies did you make?
Enough for.
Great. Thank you.
Yeah. Is there a way that Anonymous could see that as well? I'm sorry? It came from him. Oh, I'm sorry. Okay.
What?
Do we want to clarify?
So,
for
Anonymous,
while we're looking
this
at it?
I'm sorry, through the chair?
Yeah, go ahead.
This document we just received, we were told came from you, so I just want to verify that you provided a document to the city that the first line says begin vCalendar and the last line says end vCalendar, and it takes up about a full page?
I have provided two such documents. I need to know which one he is talking about. Can he? Sorry, this is Mr. Heckle, right? I don't know who is who. Sorry, the committee is speaking to me, not Mr. Heckle, correct?
Yeah, but
Yeah, this was member Josh Wolf asking you about this document to verify that you did provide this to the city.
I have provided an ICS file where I pointed out that 4 lines would be redacted if he's talking about the email I sent him earlier today. But I also sent your task force for entry into the record the specific case 19047 because I expected that to come back once they make the ICS and then we argue about which lines need to be redacted. I also sent that file. So I don't know which file that you're seeing. Is there any way for me to see what you guys are talking about?
We're looking at a file that says begin vCalendar version 2.0, prod ID, Microsoft Corporation, Outlook for Mac, blah, blah, blah. Fourth line says method, publish.
It's the metadata for an
It's the metadata,
ICS
yeah.
file, right?
Does it have a subject colon line? Then I'll know which file it is. Because like I said, I sent 2 files to, and I don't know which one is being shown to you guys.
subject colon line.
We don't see a subject
We don't have the
colon line.
email. We just have the
metadata.
metadata.
Yeah.
No. That's not what I mean. Sorry. There's a subject colon line in an ICS file. It's not the email I sent to him. Inside the ICS file, if he's showing you the ICS file, there would be a subject colon line that he printed when he printed out the file I sent him. I'm looking for the file I sent him. 1 second.
So one of these files. one of these lines of code should say subject colon. I
Was
think.
this submitted in the packet?
This is not in the packet.
So, do you know which one? I just need to know which one you guys are looking at. Sorry.
I don't.
Maybe Mr. Heckle, you could speak to where you got this.
Sorry, I haven't pulled up the exact email, but it was the one that Anonymous sent me, which identified at least 3 lines of metadata that he said he would concede, basically for argument's sake, that they could be redacted. And then the attachment was an ICS file in a TXT format.
Yes. Okay. So if yes, it should say summary. Summary, not subject. It should say summary : test subject.
Yes,
I
see that. Yep.
If it
Correct.
says that, that's the right file. Yes.
That's right. Yep.
Great. So we've confirmed that this did come from where it came from. Wonderful.
Great. Okay. Next speaker.
Good evening. My name is Linda Jarrell, and I serve as the City CIO and Executive Director for the Department of Technology. Point made. If you very smart people have trouble looking at an ICS file and identifying the RE : subject test summary, how can we expect 52 departments to correctly, consistently, completely redact information out of a file in a way that preserves and protects this city? From my perspective, I'm just an engineer. All I do is protect the city all day long against cyber threats. And it is relentless, it is sophisticated, and the technology changes daily, hourly. Being prepared and anticipating what is coming is our number one job, and it is difficult. We have investments in cybersecurity, expensive tools that help us. We have alerts. We actually contract with companies to help alert us if our systems are hacked. We have cybersecurity insurance to protect this city if it were to be attacked. And we have cyber staff and a growing need for more cyber staff, because as these threats evolve, as the attackers persist, and it is not hundreds, it is thousands a day of attacks, we have to be very prepared. And we all know where our vulnerabilities are. It's our people. Our people need to be trained not to be phished, etc. We can do that. But we certainly want to protect our records, and we certainly want to protect metadata that could expose us to potential attacks. Now, I don't know all the different ways someone could use the metadata to attack us. I do know there are components of the metadata that, if they fell into the wrong hands, could definitely be used to attack the city. That concerns me. I also know that our departments, as conscientious and as dedicated as they are, cannot be expected to reliably and consistently and completely redact items out of metadata in an ICS file in a way that would guarantee that every single time they did it, they didn't expose an IP address. That's my concern. So I just want to talk about common sense. And common sense to me, and I understand there are rules and regulations, and you are the experts and I am not. We have very skilled attorneys that can help us with that. I'm just talking about common sense and the city and how difficult this job is. And I just want you to please consider that we need to make it easier, not harder, for us to protect the city. So thank you.
Thank you. Any other speakers? Okay, I think we're done with speakers. Okay. So, Member Wolf?
Mr. Cote? And if you could put that quote from the Good Government Guide back up for us.
Happy to.
Now, the way I read this, it sounds like the public is not allowed to request a piece of metadata. You're not required to search and then review and possibly redact metadata in electronic records. In this case, we're asking for the complete data, including the metadata. So I'm curious how you feel that sentence meets the request, because it sounds like this is about searching metadata, not printing metadata.
First of all, I don't know if it draws that distinction. Second of all, even if it did, which I'm not conceding that it does, then there would be a whole series of other exemptions that kick in when we're talking about cybersecurity concerns, and that would require the production, format changing, review, and extensive redaction that my colleague, Mr. Heckel, had just described, and our view is that that's not required under the Public Records Act either.
Great. And then this Good Government Guide, you pointed out this disclosure on the other document from the League of Women Voters. Is there a
League of California Cities.
I'm sorry. Is there a similar disclosure in the Good Government Guide about how this is or isn't construed as legal advice?
I would have to review it and see.
Great. All right. Those are my questions for Mr. Cote. Anyone else?
I'm thinking of how to phrase this. So I understand, from several of our speakers, the comments about how difficult this would be, and we often don't know what the potential threats are because there are people working very hard to attack the city in many different ways. I also understand in terms of the difficulty, especially the first time that anyone would try to do this and get this kind of request, you have to figure out how to do it. And I understand that very first instance is going to be very difficult, but I'm wondering if there are ways that we can figure out what pieces definitely need to be redacted, and is there a way to systematize this and make it clear for people in departments who are getting these requests so that they could do it in some sort of automated fashion?
That's Linda Jarrell. That is an excellent point, and you would think that would be possible, and it's not. The email metadata that comes off of Microsoft is different that comes out of Google, that comes out of other email systems. So you would have to know the version, the source system to be able to type and standardize that approach. And remember, we're talking about having tool sets that would be able to read what you want, allow you to customize what you want, and then run it through a process to remove. So that tool set doesn't exist. That's not to say somebody couldn't make a lot of money trying to figure out how to do that tool set, Mr. Anonymous. So I think that is something that we might look to in the future, and we certainly would be open to using a tool set like that if it were available, and it would provide that consistency, accuracy, completeness that is so important as we do this. That's a great idea, but we don't have it today.
May I respond?
Not. Go ahead. It's your chair.
Well, sure. Yeah. Sure. Yeah. Quickly.
So she's exactly right. That is the kind of process that needs to be standardized. She's talking about me making money. I don't know what she means by that, but in 1 hour, I wrote so I'm a software engineer by profession. I run a software company as my day job. So over the weekend, I wrote a Python script that can that can redact in a standardized way any EML file. You would give it a whitelist of all the headers that must be released, like from, to, CC, the very basic headers. And it would remove everything else, put in redactions where it is. This is not, and they're not required to do programming, but they can use programming to make their burden lower. The fact that they argue it's a burden, under the Sunshine Ordinance, I argue under 6726, that's not a reason for the parts that are public to be withheld. And I can release that. By the way, I'm releasing that as open source. Under anyone can use it for free. I don't know what she meant by making money. I want public information to be public.
Okay. Thank you, Anonymous. Member Wolf?
This question is pretty much for any of the city employees in the room. We've heard a lot about how there's data in the metadata. There's information in the metadata that poses a real and severe risk to the city's data systems, the city's integrity of its data, and I suppose everything's online, so it could go beyond that. But in the case of this hearing, we're talking about two specific pieces of two different types of metadata: email headers and ICS metadata. My question is, what is one actual line on here that creates an example of a vulnerability to either a commercial or a government computer system, and what is that vulnerability result in? In essence, you're saying that this could create an entry to something. We should be able to identify which of the lines in metadata and an example of how this was used to obtain access to something. Because without actually clarifying how this data can be used harmfully, it is reminiscent of the national security exemption that we dealt with the first 15 or so, 20 years of this century. And what's crucial about that is it needs to be demonstrated how that actually is a risk. And similarly to this, we're talking about now cyber risk, but let's identify the specific section, the specific point of risk, not this generic, there are lots of things in here that could get the systems in trouble. Can anyone speak to that?
Hello, my name is Michael Maximum. I'm the City Chief Information Security Officer. Thank you, Mr. Wolf, for the direct question. I think it's a really good one.
Could you spell your name, please?
Michael Maxman, Makstman. This is actually an area where Anonymous and I are in concert. In his submission, he has already identified several data fields where there's definitely a risk to the city of cybersecurity. So as an example, we've discussed last time, and just looking at the ICS file that was given to you, line number 3, prod ID, / releases, reveals a certain type of product, actual specific program and a specific computer version of that program that, based on my opinion as well as opinion of the experts we've consulted, will allow somebody to use that information to craft specific attacks targeted at that user if that information is released. For example, there are known vulnerabilities in Outlook for Mac as they released to the public. We conceivably could have somebody craft a specific attack targeted at calendar that is using that product version. While we do everything we can to upgrade our products once information about vulnerabilities are released, the vulnerabilities are released every day, and it takes time for our IT staff to test and verify that using what the vendor has supplied to fix the vulnerabilities won't actually create more problems for us, which we've seen in the past. So we are just asking for reasonable accommodation here to not release this information, to give our IT professionals a chance to actually close the vulnerabilities and use the time, right? Not to give the attackers immediate ability to target us. Another type of information, not necessarily in ICS file that we've seen in the email file, is IP or Internet Protocol addresses of city systems, which are not public information, but could be targeted specifically in a couple of ways. One is to compromise those the systems behind those internet addresses, or to actually craft an attack called denial of service, which will prevent delivery of email to the city. Either type of attack is definitely something we want to avoid. So we would not want to release that kind of information. I want to then go back to something that Anonymous has said just in his reply now, which is that he is interested in actually seeing specific types of data in the metadata. And I would say that's a pretty reasonable request. For example, if the Anonymous was to say, I am interested in this data from type who is the calendar invite was sent, I think that's something that the city can actually produce without releasing the metadata. I think the requests right now are just give us the metadata, right, and redact what you need to, which would basically require our staff to go through the metadata and try to figure it out. If the requests were, please give us this data, whether it appears in the metadata or could conceivably be produced from the record itself. So I think last time we talked about how Anonymous was saying the time zone should not be redacted. Well, if the interest is for us to produce the time zone, we can produce that. It doesn't have to come from the metadata. It could come from other places in the record itself. If there's an interest to say who's actually created the calendar invite, the city could probably look at that and produce that. I think that's a very different discussion that I'm hearing now, and I actually want to encourage that discussion to say, why doesn't the requester ask for data that is of interest, and the city will try to come into the best instead of asking for metadata, right? Without the clear understanding of which will require then redaction.
Go ahead.
Go ahead. I just have a question for Anonymous. Based on what you just heard, is any of that data, would that data be of interest to you? Would that data be something that complies with your request without them giving you the metadata?
So I believe they're misusing the word metadata. So that's one of the main issues that we're having here. What they call metadata and what I call metadata is not the same thing. And you can see a definition of metadata on page, sorry, it is page 86 of your PDF, which is data about data contained in a record that is not visible in the text. Now, I have to use the League of California Cities definition because there is no legal definition, nor is there a legal exemption for it. So that's the best I can do, which is data about data that is not visible in the text. So if you go to what Mr. Maxman is saying and you look at the ICS that they have provided to you on my behalf, there is the information in here. Some of it is metadata and some of it is not. We should separate out the concept of native formats, which is a separate law, versus metadata versus data. Those are two separate legal questions, and the format question is not the same as the metadata question. There are two separate laws about those. So if his question is, can they provide me certain data without providing me a native format, if a person requested that, then the law allows them to do that. Because the law says in San Francisco, not in California, but in San Francisco, 6721A defines both the public record, the record itself, and public information, which is defined as the content of a public record. They are both public and disclosable in the city of San Francisco. So he's right. If I had asked, give me the modification timestamp, give me the time zone of this record, they would have to produce that whether or not they use a native format. But in my request, I write my requests in a very legalistic manner to try to avoid the government loopholes that I've experienced in other jurisdictions. I asked for both the format and the metadata and the headers, everything, right? And it is my right under the Sunshine Ordinance not to have to know what could be in the record. How can I possibly know what is in their records until they give me something, redact half of it, and then I come to the task force and argue against the city? It's not. I don't have a legal obligation to know what parts of records exist in the city. So I would say that is that possible that a person could do that, that I could do that? I could ask tomorrow, give me the location and time zone of this calendar entry, and they would have to provide it even without an ICS? Yes. But if I asked for both the easily generated format and the metadata, then they would have to come up with legal evidence, an argument against both of those. Because as they have themselves said, some of these things is a public part of a record, and 6726 is just very clear. They have to give me the whole document and only remove the parts that are exempt. One of the examples that wouldn't meet the long discussion he gave you is something that was discussed by one of your members in case 19047, which is the timestamp when this calendar entry was created. There's just and the modification timestamp. So that's very interesting when political controversies occur to know when a calendar meeting was created. There's just no way for them to give me that information from printing it from Outlook. And as they have already, I think Mr. Heckel said this before, well, one of the problems they have is, how do you know which view you want to print out to give me? Well, you don't. That's why you give the record itself and then redact whatever you want to. So
that's an interesting argument, and I can't certainly speak to the legal merits of that argument. I do want to point out to this committee, sorry, I started speaking without permission.
Yeah, go ahead. Finish your thought.
Is something that was just said, that you don't know what metadata looks like until you see it. So then the arguments that the metadata redaction could be standardized also wouldn't be valid necessarily, because we really have to look at the metadata for each type of record separately. If we knew exactly what was in the metadata, if it was so standardized, then there wouldn't be any question about wanting to see it, because we'd have it, right? So the metadata is really not standardized. It is really different, right? And you would have to look through each one potentially, have the records that requested, whether it's different calendar types and different applications produced by different applications, whether it is 2016 Outlook application versus 2012 Outlook application, right? Whether it's the email was received from a Yahoo or sent to a Gmail account, which some of the city agencies actually use different providers. So this is where I think the standardized question is kind of interesting. So that was my only point, and I certainly can't speak to the legal one.
Okay, thank you.
Chair, may I respond?
Do other members have questions?
Before you do, let's see if we have any other questions among the task force here.
I'm not sure this is a question so much as a comment amongst us first, which is what's been brought forward as potential security vulnerabilities in these two forms of metadata is in the ICS, the version of the Microsoft that they're using is a concern due to security vulnerabilities, and there are quite a lot of high red zone security vulnerabilities according to a readily accessible database for Outlook. Presumably, they're using one of the more recent versions, so the fact that these it more concerns me that we have a city using tools that have these vulnerabilities than the idea that if they don't reveal which version, then the vulnerability still exists, and there's not all that many versions of Outlook. So this is my concern, is that basically they're saying that their email system is vulnerable, and if the public finds out what version of Outlook, they could take out the email system, and that seems like a weird argument to not release.
There aren't that many options, and you could start knocking them down and figure.
The other thing is the only other instance that's been cited for the email metadata that could be problematic is the IP address, and I think I can understand why an IP address would be concerning. But in both cases, we've identified one line that has a common prefix to immediately identify it using, standard text-based search and replace parameters. And so what I'm not hearing is an actual overriding case why this data can't be successfully, reviewed.
The two other things come to mind for me, and one is I think this might be the tip of the iceberg, And I think the city might need to start getting ready for more requests like this regardless. And unless there's an expectation that, we or others, or depending on how long this takes, will say, okay, there's a blanket, no metadata will be released. I think we are going to have to figure out ways and systems for dealing with this. And we need to start thinking about this now.
I mean, briefly, Anonymous, I think you had mentioned, and maybe, because I know we gave one of the folks from the city here a chance to respond, that list of metadata that was provided to us. Can you tell us, in your opinion, which lines you would expect to have redacted out?
Sure. Are we talking about the ICS again, or a different? I've given you a lot of documents.
Yeah,
the last few weeks. So.
The one that had the summary test subject?
The ICS.
Yes. Okay. Sure.
So which ones?
So this is my own calendar. I gave. Let me be clear. I'm not. I take my security seriously as well. This is a test thing I've made for you guys. So I think I actually agree with Mr. Maxman. I don't agree with Member Wolf. They should remove the version of Outlook. That I think squarely meets the 6254.19 definition of an information security record that may reveal vulnerabilities. Maybe it's not a good idea that they're using these versions of Outlook. I don't believe that that's relevant to the case of whether it's redactable under 6254.19. So I would remove, in my own calendar, the word for Mac, or in their calendar, version 15.0. And I've even provided an example to your task force. It's not yet in the record of how to do that. I would also redact, possibly, the UID : and X-entourage _UUID : They're the same number halfway down the page. And the reason I would do so is under 6254.19, increased vulnerability for an attack. Now, they are misusing the word spoofing, so I want to try to explain what spoofing is. I am not an information security engineer, but I do security engineering when I design my own software systems to make sure that those software systems aren't vulnerable to various kinds of attacks. And that what you want to protect against in spoofing is to make sure that a person cannot transmit a communication that would appear to be as if it's coming from someone else. That's why on the email, I actually redacted, even though they failed to redact, I redacted for them some of the records before re-entering them into the public record, because I actually agree that some of those headers could aid in spoofing. But in a calendar, the one you're looking at, the only one that I think can have any possibility of doing so is the unique identifier of the calendar meeting, because it could allow maybe someone to, send you an invite on that calendar. I think it's a bit far-fetched, but it's also not in any way something that is of public interest. In San Francisco, you're not allowed to redact things merely because of a balance of public interest, but I think under the CPRA, not the Sunshine Ordinance, you would be able to argue that the UID and the X-entourage UUID lines could be, the values, not the actual line, could be redacted. I also told Mr. Heckel that he may want to redact the line called R rule : frequency equals weekly, which is near the bottom. There's many R rules. An R rule is a standardized a data structure that tells you that there's a recurrence of a particular item. This last one tells you that my test event is a weekly repetition of this test event until a certain timestamp. That is not an information security record, but Mr. Heckel claims that future meetings are, they're exempt under some other exemption law that has nothing to do with information security. I was just pointing out that there's another thing that you might want to redact for other reasons. So to me, there are three lines that if I was the cybersecurity person, I would redact three lines from this: the version for prod ID and the two values, which are the same value for the unique identifier for the meeting. And then if I'm the mayor, I guess I would also redact the last R rule. Now, the two R rules at the top, they are telling you how often daylight savings time switches. We talked about this at the last meeting. There's nothing secret about that information.
Okay, thank you. Is there any lines, back to the city, I don't know who wants to speak on this particular one, that you would add to that by chance, or would you? I know this is just one example, but just in this particular example. Yeah, I mean, to start with, though, are there any, I know he spoke to 3 or 4 lines in that document you gave us. Are there any that you would add to his list?
Well, possibly. I mean, I'd defer to the Chief Maxman on that issue if you'd like to hear from him. But Anonymous spoke at length. I'd just like to respond to some of those points.
You got to speak up.
Okay. Anonymous spoke at length, so I'll just respond. So under his logic, I mean, he has these exceptions swallowing the entire Sunshine Ordinance, basically. Under his logic, because he says that there are all kinds and varieties of data that are inherent in metadata and are embodied in native formats that he doesn't even know if they exist, but he'd like to know. So by that logic, we should just give him the passwords to the city system and give him a user account to whatever directory he'd like to view. Obviously, that's not what the law requires. Obviously, that's not what the Public Records Act or the Sunshine Ordinance requires. The Sunshine Ordinance does not abrogate the cybersecurity exceptions in the PRA. That's nowhere in the Sunshine Ordinance. I mean, let's play this out a bit. Let's say that the next request goes to the Department of Public Health, and a request is made for hundreds of files that includes confidential health information of patients in the system. And let's say that Anonymous requests or someone else requests all kinds of metadata associated with those files. And some of the metadata, if read properly or fed into a computer or analyzed by someone with computer science expertise, can decode or decrypt or just interpret that information in a way that an untrained DPH employee might not be able to. So in that scenario, and let's say the employee gets that request, they're not used to those types of requests. They call their IT person. It's an immediate disclosure request. They don't have time to do an extensive review with the IT professional. And now we've produced all kinds of confidential health information. The city's then violated HIPAA and revealed health information of its citizens because these custodians cannot be asked in every case to provide extensive metadata, and to do so and to impose requirements across all records requests that would require consultation, extensive consultations with IT professionals is burdensome, it's not feasible, and it's just not required under the state of the law. Maybe there are evolving practices and standards that can be looked at. Maybe the Sunshine Ordinance can be amended to address some of these issues, but there's just no clear guidance in the law, and there's just really no practical way to not only redact some of the security sensitive information, but the issue raised here is that there's information that's subject to other exemptions, privileged information, confidential health information, and the like, that can't easily and reliably be generated and redacted in a reliable way because you need a lot of expertise and a lot of consultation with the appropriate professionals to do so.
Did anyone have? I mean, I think that's an interesting point. I can imagine, let's say, if it were a image file that presumably has a bunch of metadata associated with it, and somewhere in that image file, let's say it's a scanned image of a medical record, and somewhere there's, or let's say it's even just not even a medical, just something that a portion of it would have to be redacted as an image. If you were to ask for the metadata that presumably makes that image, I'm not sure how you would redact that portion of the image from all the characters that make it up. So I mean, I think it's an interesting.
Let's play out that photo metadata for a second, because that metadata is probably one of the easiest ones we can wrap our heads around. Mm-hmm. If you take a photo with your phone, the time you took the picture, where the picture was taken in GPS are both recorded, along with a bunch of other stuff that probably doesn't matter for the purpose of this conversation. Let's say that a city department or a city elected official posts a picture that appears to not be what is displayed. It looks like it's a recreation because someone was there and they're like, I didn't see this. So they file a request asking for the complete file to get this metadata to verify that it's a legitimate photo from the right time and place. I think at least for me listening to that argument, it sounds like that metadata absolutely should be turned over to verify the authenticity of this photo.
The problem is people don't have to say why they need it. So,
well, there's no. I think you'd make a really hard case. No, there's stuff on a phone photo in metadata that is also a security risk. So basically, metadata inherently has both security risks attached to it and data that isn't part of the integrity of the actual record. I don't think there's any way that we can just say that the metadata doesn't matter. Because in the photo case like that, I couldn't understand an argument why we wouldn't allow the location and the time to be turned over. Essentially, what I'm hearing is that from the city is that this process of filtering through metadata is technically complicated, requires a lot of time and energy, and specific talent within the city that's limited. I don't see anything in the Sunshine Ordinance that allows the city to say this is too much work. In the same way that if there was a public document that was tens of thousands of pages and some of it needed to be redacted, the city can't say we don't want to read through the document.
the option is to create a timeline over which the information will be released. Like to say we need more time to produce this, we can produce X number of documents per week for the next 52 weeks.
Right. I mean, I was speaking of like a single 1,000-page document in my case, but yeah. So that's where I'm at on this.
Museum case is a perfect.
Right. One question I did want to have, and I think we kind of talked about it when this came before the full task force. Maybe we can just briefly touch upon it a little bit more here. Is we talked about the information on the left side and the right side of the colons, and if there would be any security concerns with at least having what I'll call the header, or the part that's on the left side. For example, we talked in the example he gave us, where it says prod ID : and then there's the version of Outlook. If we were to have redactions, is there a security concern from the city standpoint of including the header and just redacting the part that's to the right of that?
I'm seeing heads shaking no and somebody standing up.
Yeah. So if
Do you have
someone
anything
who
to
can
say
speak
about
to that, or like Anonymous spoke to UID : and then it had a unique letter number combination or X entourage. I'm just thinking if you kept, let's say, the word UID : and then redacted the part to the right of that, at least. If we move into the direction of that really we have to look at each line by line. I'm just getting into what part we should conceivably look at.
Or
seeing
are you
redacted.
also thinking that at minimum, if metadata is requested, that we have to give we should say that what is to the left of the colon must be provided?
Right, at least a starting point. Right, at least show what the headers are. Is there a security? So maybe you could speak on that.
In this case, for the ICS file, there's nothing security related. There's minimum security risk to releasing the header without, or the metadata line prior to column, right? That is not to say that a different document or a different record may have some headers that are security related. I cannot come up with an example at the top of my head. Certainly can do the research, but there's lots of different type of data. If we were to open this, right, that may have a security related, just releasing the actual what is included in the metadata may open up security risk. So I think want to reiterate the point. I think it's Mr. Wolf said that, or maybe it was you, the chair, who said that yes, there's an understanding that this is burdensome, right? That untrained personnel can't really execute this, right? So it's not a matter of our regular folk who look at content, right, and redact content. You would have to have specific expertise available in the department itself, right, because they are the holder of record, for example, my team would not be possible for my team to redact department records. Otherwise, we would cross the line of who's the holder of record, right? So we can advise, but they would have to have internal expertise. So all of the 52, 54 departments would have to have an internal expertise to be able to do this, because the records do vary. Even the metadata varies for a simple thing like the calendar invite.
Thank you.
So I'm thinking of an odd parallel question, which is, if you were to request the HTML file for the city's homepage, you're essentially asking for metadata that is possible to generate in your own browser by
Yeah,
going
I don't need to ask for it. I can get it.
Right, but
Yeah.
I'm curious if they would provide it or say, no, this is metadata. It's just sort of a thought bubble. I don't have anything to expound upon, but...
Can I answer that question?
Sure.
I'm actually going to take the city's side here. That is not, no one would call that metadata, and that's why no one would give it to you. The problem we're really having here is that me and I think Mr. Maxman and Ms. Jarrell are using technical terms, I would hope, while the people who may not be computer scientists or network administrators or software engineers are in that boat are not using the words in their technical way. And nobody would consider, I mean, maybe they're going to disagree with me, but nobody's going to consider the HTML of a web page the metadata. The metadata for a web page would be the time when that web page was published in the Git repository or to their content management system or anything like that. So if I requested that record in the content management system, which is not the same thing as requesting the published HTML, then the question would become not whether they have to give me the HTML in the page, but whether they have to give me who wrote that file, what the time they wrote it, which is what we call metadata. And please have the city disagree with me if it wishes to.
And that would also include things like versions and who made what changes when.
Exactly, which under the Sunshine Ordinance, draft versions are much less exempt under the Sunshine versus CPRA.
I'd just like to read into the record. This is from Webster's Dictionary. This is the definition of metadata. Data that provides information about other data, period. So we can have a semantic argument about who's a computer expert, and various computer experts might disagree over what's metadata and what's producible and what's exempt, but I think we haven't even gotten to an agreed upon premise over what's encompassed by these requests, where he's saying, give me a file in a native format with all the metadata associated with it. We don't even have a common agreement as to what kinds of data that may be, and I think that's a pretty fundamental problem if you're going to be making decisions over what's a security risk and what may be subject to another exemption and what should be disclosed.
And part of what I'm thinking is, I think we talked about looking at a standardized type of format, and you spoke to why that would be difficult. I mean, what goes through my mind is, what if it's a very unique piece of software that perhaps just one department or agency uses, and there's a request from, I mean, to a large standpoint, I'm sure most, if not all, the city departments or agencies use some form of Outlook. So it's probably would be more realistic to train staff on what to look for or not look for in metadata for things like that. But if it's a specific tracking system that public health uses or something that public works uses that's very unique to them, I could see where there may be data in there that's potentially more difficult for your typical IT person without particularly trained in that software system to know what may or may not be disclosable or a security risk. That's just a concern I have. I don't know. Maybe.
I mean, it seems to me that this comes down to only two questions. One is, is a public document public in all of its aspects, including that which is not the printed part of the document? In other words, the metadata, or however we want to phrase this. So that's the first question, is the document itself public, including all of the other parts of it that aren't the written word attached to the document? Secondly, the question is, if there's consensus between the city and the complainant that there is information in metadata that does need to be omitted or blocked out. Is the process of having to go through metadata under the Sunshine Task Force, because that's our governing document, not the CPRA, which does seem to indicate otherwise, is the process of the burdensome process of going through that metadata make it immune from the task force? Those are the two questions that are in front of us the way I see it.
We have a new speaker.
Yes, I'm Mark Upchurch. I'm the Chief Information Security Officer for DPH. And I've listened to some of this dialogue, and I just want to make one point that I think has been missed here. Anonymous is focusing on calendaring header block information. I also want to mention the fact that the header information on email is more complicated. It includes trace routes, it includes host names, server names, and IP addresses. And the format and content of a header block for each individual email could be, and is usually, significantly different based on the route that the email takes. So while we are spending a lot of our time focusing on calendaring, that's just a part of the complexity of what it would take for us to comply with these requests and the amount of time it would take us to process this information, should we receive such requests. I just want to enter that into the record.
Thank you.
But I think it again circles back to, are the non-written word part of the documents public? And assuming they are, is the burdensome process to go through those
Reasonable.
Right. To deny through the Sunshine Task Force or the Sunshine Ordinance?
Go ahead.
Michael Maxwell. So I do think this is a difficult question, because where do you stop, right? So is the data in this calendar, in the header of this calendar, is that metadata? What about the data about the system that holds the metadata? Is it also metadata? What about our system? What about the data about the systems that provide calendaring for the city? Is that also metadata? Where do we put, so I can envision a scenario where Anonymous or a different someone says, okay, well, tell me about Outlook. Show me all the data about an actual application that has produced the metadata that is attached to the actual email record. And why not stop there? Show me the metadata of all the systems that are supporting the systems that are actually producing the applications that are producing the email. So we have this is where I think we're looking to you to really set, and we've got a perspective as well, to really say, okay, well, where do we, because we've got if you trace it, we have a lot of data and we have a lot of systems that are connected to each other, right? Why do we, why should we believe that the requesters will only stop at this one particular point? If we open the door to the metadata, or to specifically to unencumbered questions about metadata, where do we stop? Because then we would have to redact every possible way up and down the chain of systems. And unfortunately, that is what information security concerned about, right? But information technology as well. We've got multiple systems up and down the stack. What about the information about the network that is actually carrying the emails in the city to Anonymous, right? Is that part of the metadata? I could see there's interest of when was the actual, what was recorded in the network at the time when the email was sent. Who else was sending the, another packets, right? So this is where I think the challenge is not just to focus on this particular piece of metadata, but to think of this, how far we can go. I think the request for the actual record that is recognizable by the what you'd call a regular person in the department, that there's no dispute on that. It is the technical piece about the data, of all the systems that might have produced it, of all the systems that support those systems, about the networks that carry that particular record around and where they're stored, right? That becomes very problematic, and I could see us, and I want you to think very carefully about that to see us where do we stop at that point.
I think.
May I speak since Mr. Maxman spoke?
Briefly, I have a follow-up question. I understand the city's position on that. Can you or someone kind of link that thought to some text in the Sunshine Ordinance that would support that concern? Like, are you talking about a specific exemption for? I don't want to put words in your mouth. I mean, obviously, there's some security concerns you have, which I think that's a valid concern. But to Member Wolf's point as well, I think we have to tie it back ultimately to the text that's in the Sunshine Ordinance. So, what portion of the Sunshine Ordinance would you invoke to protect that?
Sure. So, not to rehash things, and I know you're asking about the Sunshine Ordinance, but just as background, the PRA does have those two exemptions that relate to information security and technology systems. That's 6253.9F and 6254.19, both of which have been cited extensively in the context of Anonymous's requests. And then in the Sunshine Ordinance, I just want to offer what I feel is a correction that I don't believe it's true to say that the Sunshine Ordinance, first of all, the Sunshine Ordinance does not abrogate those exemptions. It does. There are exemptions, admittedly, for other types of information in the Sunshine Ordinance that it does. 67.24 in the Sunshine Ordinance does limit certain exemptions in the PRA. It does not limit those information security exemptions. Also relevant in the Sunshine Ordinance, as I mentioned, 67.21L addresses production in electronic formats. And again, I'll just read this portion into the record. Inspection and copying of documentary public information stored in electronic form shall be made available to the person requesting the information in any form requested which is available to or easily generated by the department, its officers, or employees, including disk, tape, printout, or monitor. So our argument here is that all of the steps that go around with producing these types of formats, and so first you have to get to the format. And I talked about the Outlook calendar example. An Outlook calendar is not a record in a simple sense. It contains public information. I fully admit that. But you can view the information in an Outlook calendar probably hundreds of different ways. There's daily views, weekly views, monthly views. There's all kinds of buttons you can push and permutations that will give you a different file that may be an ICS file, a native file, similar to an MSG file. So, as I said before, I counted 5 steps to start with an ICS and then get to a step where you could actually do redactions, assuming you need to do redactions of ordinarily exempt information like privileged information, and then maybe if you are going to produce metadata, the security risk information. So just to get to that step for one calendar entry, Anonymous has requested days and days and weeks and months of calendar entries. This is one entry on one day. That's 5 steps. Then you get a page with 40 lines of metadata. Then you have to consult with an IT professional to identify what the security risks are and redact them out. There may be information in OCR and other types of records that also requires consultation with the IT professional to redact, like the privileged information that appears in the metadata when you're trying to withhold it completely. So all of that goes to the point that these types of productions are not easily generated. That's what we're saying. So it's not within the meaning of 67.21L. I'll also point out a clause in that section that says, nothing in this section shall require a department to program or reprogram a computer to respond to a request for information. So we can debate whether some of these steps are programming a computer. I think Anonymous talked about the city buying software from certain sources or implementing certain systems that would enable the city to respond to these requests in a way that's more satisfactory to him. Those may involve steps of programming or reprogramming a computer or the city's systems, and we think that's explicitly not. The Sunshine Ordinance contemplates these situations and provides limitations on them.
Okay, thank you. Member Wolf?
So again, I'm hearing that there is a lot of process and procedure in order to make this happen. And in the case of the ICS, I think you can possibly make the case that the documents don't exist as ICS documents inside the system until they're actually saved. But when we talk about email headers, each email document does contain the headers built into it. It is not creating a new document, unlike potentially the ICS documents. I see head shaking no.
I don't know if I would concede that. I mean, I think you'd still, if I may.
Go ahead.
I think you would open it as an MSG file, right? And then it would sort of inherently contain the metadata. And then to show the metadata, you'd have to convert it to a TXT, and then if you want to redact the TXT, you'd have to convert that to a PDF and then perform the redactions on the PDF.
In terms of the workflow, you're exactly right, but there exists in every email inbox a file for each message that already has the headers attached to it. There is a document for every email that has the headers attached to it. So you're not actually creating a document, you're exporting a document. Let's not debate that right now, because that's not really the central point of of what I'm trying to get at. What I'm trying to get at is the fact that what we have is a debate over whether these material is part of the public document, whether the metadata is part of the public document, and whether or not the work involved to screen that to make sure it's safe for the public is a legitimate reason under our city's Sunshine Ordinance to not have to do the work. And so I'm asking I'm asking the follow-up from what my colleague did. What section of the Sunshine Ordinance indicates that work that clearly would take a ton of time and maybe overburdensome, where in the Sunshine Ordinance does it exempt you from needing to do that if it's requested, if it is a legitimate public document?
67.21L.
My reading, when I look at 67.21L, is it seems to indicate it's an or, not an and. So it says it's which is available to or easily generated by. So it is available to, because we can make it very easily. We're not asking to make something that's, that you can't save. Obviously, you open it up and hit save. I did it in 5 seconds, when I tried it, on my computer. So it's obviously available to. It doesn't say available to and easily generated. It seems to be either or. So I'm not sure exactly how L is applying. Well, I could see it might not be easy, but it's certainly available to.
I don't agree that it's available to. It's not available in a practical way. We could debate the meaning of the word available.
How is the email header not available?
Because it has to be converted through several steps to arrive at the stage where you can perform the metadata analysis. And then to perform the metadata analysis requires an extensive and highly technical and burdensome process. And, we can disagree. That we're reading 67.21L to say that if the steps required to arrive at the product that Anonymous wants in this case, are not available or easily generated, not within a reasonable meaning of this section. And the section that points out that a department is not required to program a computer, I think, is instructive because it speaks to the very same issue. We can get into the semantics of what's programming or reprogramming a computer. I think some of these conversion steps arguably are programming a computer. I mean, Anonymous talked about taking a TXT file and then rewriting several of the code sections and replacing them with X's and so on.
So is my understanding that you're saying that, let's just say that you were to open up a calendar invitation, hit save, and it is what it is. So your contention is really that's not available because it has to go through a more complex process of review and redaction, and therefore that actual file that you would save, let's say, like I said, in 5 seconds, actually isn't available to the public because it contains certain exempt information that might be a security risk. That's your point.
Yeah, I think that's right, and I think that's in the Sunshine Ordinance. And I also would go back to the PRA exemptions, which are not abrogated by the Sunshine Ordinance. The Sunshine Ordinance admittedly narrows and limits some of the other types of exemptions, like drafts and other things in 67.24, but it does not limit 6253.9F or 6254.19 of the PRA, and it doesn't even really get into cybersecurity exemptions and limiting them. So if the drafters of the Sunshine Ordinance wanted to claw back that exemption or narrow it, they could have done that in 67.24.
You can go first. I'm about to open a can of worms.
Sure, something quickly, and then I heard Anonymous say something too. I think one of the challenges here is the idea easily is available or easily generated by the department. I think one of the challenges we're presented with is that volume also matters. If somebody made a request for 1, 5, 10 documents, and maybe the amount of time that it would take someone to convert them and redact as needed, and we'd say, well, that's easy, you should just do it. The question is then it comes to volume, but we get volume questions all the time, and we often go back and say, well, yes, you need to spend the time to do it. And I don't know how we address this.
So I really would like us to get back to whether or not the document's non-visual part is a public document, because if it is, then the burdensome thing comes up. If it isn't, then the burdensome thing doesn't come up at all.
Right. Very good point.
And so the way I would like to go about that,
I'm hearing
and
Anonymous.
we'll get to you in a minute. Please be patient with me here. The way I would like to go about that is to go back to the photo example. So I don't know what department maintains the city's website as far as a request goes, but the easiest example is to use an example of a photo from the city's website. So we'll just assume that the city itself responds to that instead of identifying which department deals with it. So if I click on the news and free financial planning day at the library, I see a photo that looks like it was a cell phone photo at some sort of a luncheon event. And let's say as a reporter, I'm wondering what event this was. So I want to find out when that photo was taken. So I file a request asking for the original photo file as made on the phone. What do I get when I request that in your mind? Because there are metadata information in there that I could then get that probably do have some level of cyber issues, because I can find out the MAC ID of the phone through that photo request. But what do I get if I ask for the original photo file from a camera phone that was taken and used on a city website? And it's to everyone in the city to respond how best they see.
Well, I mean, just speaking for myself, it's a hypothetical, so I can't. This isn't some definitive answer. I mean, I think that, narrowed information, there's substantive information you're referring to. I don't think the city's trying to withhold that type of information. So it could just be asked directly to the department. The photo could be provided, and I mean, I don't know if it could be provided in like the native format. Maybe it could, but as you said, that might provide information about, most city employees don't have city issued phones. They use their own phones for work. And so if they took a photo, someone in like some communications department took a photo, and then you want metadata from that phone, I mean, there's obviously some privacy issues that go along with that. So I don't know. I mean, it's a case by case basis, but I don't think the city's position wouldn't be we're not going to give you any information on like when that photo was taken.
I mean, we don't need to make it hypothetical. I could actually file the request for this exact photo and see what comes out.
That's your right.
Does anyone else from the city have a response around how the handling of metadata attached to photos? All right, thanks.
I mean, to your first point, I think we kind of dealt with this in the hearing from the full task force, is that Anonymous was looking for, I think, who an invitation may have been forwarded to or who set it up or something that clearly was not visible on the PDF printout.
I think
right?
who generated
who
calendar
generated
items.
it or something,
Yeah.
right, on the calendar, right? And then looking at 6721L, it says inspection copying of documentary public information stored in electronic form shall be made available. Just leave it there. I would absolutely consider that type of information is public information. We're not talking about security stuff. So I think, at least to me, there's at least portions of that metadata that I think would be covered under the Sunshine Ordinance. That's kind of where I'm landing.
Are you suggesting that requests need to be made in a specific fashion?
Well, that's what I'm wondering if, I mean, it's not a perfect answer, but I mean, I wonder if at least it wouldn't get us through some of this where instead of saying just give me a dump of all metadata, say I'm looking for the metadata in these categories, that deal with who it was forwarded to, when it was created. You might not know the actual header name, but at least it would give some guidance versus...
So I just want to draw attention to the line in the Good Government Guide that Mr. Cote started by showing us, which I don't know whether that is actually supported by the Sunshine Ordinance, but what you're describing is essentially asking to search through metadata, which is explicitly described as something they don't have to do in the Good Government Guide. But where I'm at is that if any of the metadata is a public record, then all the metadata is a public record, although some of it may not be releasable due to security concerns. And I think that the case that you made about some of the metadata being a public record means that all the metadata is a public record, although some of it does not need to be released due to concerns in the same way that police records are public records, but much of it doesn't have to be turned over.
So then are you suggesting that, so if it's all public data, then our role is to help determine, to help with the city's guidance, draw the lines about what...
I mean, honestly,
broadly
it
be
sounds like
redacted?
the city's guidelines and what, like, if the city were to come to the conclusion that the metadata is a public record, what shouldn't be disclosed, it seems that the complainant and the city are aligned with what shouldn't be turned over. The argument is that the work involved in identifying that is burdensome. And that, to me, is our question today, is whether that burdensome makes is a legitimate exception in the Sunshine Ordinance. And the only citation we've heard to justify that is 6721L.
I mean, I think the one thing we have to consider when we look at at that is, instructions for things that, let's say, phone numbers or medical information or things like, I think you can give that direction very, easily to people who'd be dealing with public records. It sounds, at least from what I'm hearing, is that even how you describe these certain parts of sensitive metadata may vary from program to program, whatever. Like, for example, we talked about the field called UID or X Entourage, but I have no idea if those header names are the same in Gmail or Yahoo Mail or some other things. I presume they aren't. So it's not like you could just issue a directive to city departments and say, okay, release all metadata but exclude any field that begins with this, 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 and this. That's somewhat different than saying, don't release phone numbers, addresses, social security numbers. I mean, so I'm not saying I'm landing one way or the other, but I think it's a more complex question.
I mean, I think that it generally is not our place to proactively decide what is and isn't redacted. The way that it works is that the department makes a decision what they want to redact.
Right.
The member of the public receives that redacted document, which should have a reason for each redaction. And then if they feel that the redaction isn't appropriate, they come to us. It isn't our place to be proactively identifying what in the metadata can be redacted. I think that the complainant and the respondent are in agreement of what should be redacted. I don't think there's any debate there. The issue is whether they should have to go through this process in the first place.
Hello?
Yeah,
We're still here.
yeah,
Thank
we're still
you.
here.
May I know the city has, may I respond to some of the things the city has said, or?
Sure.
So they have cited 6721L, and we've read this so many times, which is that inspection and copying of documentary public information stored in electronic form shall be made available to the person requesting the information in any form requested which is available to or easily generated by the department, et cetera, et cetera. The word generate is defined by the dictionary as to bring into existence. And as your own task force did in 19047, one of your members generated an ICS file in 5 seconds, I think they said. It's that simple. And when they say this site, I'm going to go through each of the citations. 625.3.9F. What 625.3.9F says is only the electronic form in which it is held by the agency can be exempt under 625.3.9F. If they argue it's not held under ICS form, then 625.3.9F cannot apply by the terms of the words in 6253.9F. Their final exemption is 6254.19, and they never read you the second sentence of that exemption. So I'm going to just read you the full 6254.19. Nothing in this chapter shall be construed to require the disclosure of an information security record of a public agency if, on the facts of the particular case, disclosure of that record would reveal vulnerabilities to or otherwise increase the potential for an attack on an information technology system of a public agency. Period. Second sentence. Nothing in this section shall be construed to limit public disclosure of records stored within an information technology system of a public agency that are not otherwise exempt from disclosure pursuant to this chapter or any provision of law. Now, the final point about whether the parts that, whether or not, I actually, by the way, your question is the most popular question on their San Francisco Next Request public website. There is a JPEG file. It is the most popularly downloaded file, apparently, a JPEG, image8476.jpg, that has been released by one of the government agencies. It is, I'm not sure which agency. I downloaded it. It has all of its metadata, as you would expect when someone asks you to produce a JPEG. It tells you which camera created it. I don't see any MAC addresses. I'm not sure why in the world a MAC address would ever be stored inside a photo or even an IP address. That's not generally how JPEG metadata, which is also known as EXIF, works.
Yeah, that was
the
just
final
a slip of
citation
concern.
I would have you give is the Supreme Court case in Sierra Club versus Superior Court, where they found that if the government gives you PDF records and they have admitted that the PDF converted versions are public records, and they ordered that Orange County would also have to give the native GIS electronic databases. Nobody has discussed that case, so you may want to read that case on your own later. It's in my packet if you want to. It's in the agenda, the whole analysis. It's on page 97 of your PDF, an analysis of Sierra Club versus Superior Court.
Linda Jarrell again. So I just want to make sure we have the perspective here. I understand. I am a big proponent of public records, and I have been delivering public records as a public servant for over 30 years. What is getting lost here in all the discussion of the technology and the files, et cetera, that I know is not in your rules, but is common sense again, is the tremendous risk and disservice that is done when we release information that could cause harm to this city. I want you to think about what happens when we have a breach and we have something that disrupts our city. It could be traffic lights. It could be public health. And we're not talking about cybersecurity right now in terms of its impact, but I can tell you some very scary stories that happen all the time for them. They're incredibly serious, and I think this would be a different conversation if we could help you understand what is happening every day to our systems and how they are under attack. It could be the court system. It could be security systems. Any of these systems that providing information would make them more vulnerable is a disservice to this city, causes harm to the city and cost, and to the community. I really need you to remember this as you make these decisions. Thank you.
Member Wolf.
What I'm having a hard time understanding is that it sounds like there's consensus across all parties that there are data in the metadata that does lawfully need to be redacted. Everyone agrees with that. What I'm hearing from the city is either that it's overburdensome to go through this metadata and redact what needs to be done, that it requires skilled labor that there isn't enough of. And now I'm hearing that if they were required to turn it over, they might accidentally release information that could put the city at risk. We've heard the same arguments from the Department of Public Health, from the police, that these requests deal with sensitive information and the process of redacting it safely is difficult and we could make a mistake. I don't know whether we've actually heard that from either the Department of Public Health or the police, but
Maybe in other cases.
I've heard that in conversations interviewing, not necessarily in my role here. But time and again, the fact that this data is sensitive or it would require work to redact it has never been accepted by the Sunshine Task Force. Another example was a case dealing with video recordings. That, yes, there are elements of the video recording that are of a sensitive nature, but there's elements that are not. And even though the city didn't at that moment have access to the video editing software that was necessary to properly redact the video, was not enough to convince the task force that that's not a public document. It is on the onus of the city to figure out how to get the parts of it that need to be redacted. Maybe it's using a VCR. I don't know. The similar situation, I don't see any difference here with metadata. We've talked about how a photo, requesting the original photo, there's no reason not to turn over the photo. In this case, Anonymous described how a photo was the original photo that had the metadata, and I apparently incorrectly spoke about MAC addresses being attached to iPhone photos. I just don't see any argument other than the burdensome thing, and when I listen to the members of the city, we've heard some points from the California Public Records Act, but I haven't heard anything from the Sunshine Ordinance, which is essentially our Bible, about how because this is such a burdensome amount of work, it should be exempted from being turned over to the public. And that's really what we're asking you to put forward is, where does this burden come into what's labeled in the Sunshine Ordinance? And I don't see that. I haven't heard it today, and that's where I'm at right now.
I mean, I'm not sure that we can. Ultimately, I think this is something we should probably, in some way, have a larger discussion about. I know we brought up a lot of points, and I think bringing it back to the full task force under, I think the way that you propose looking at it makes a lot of sense. You know, number one, is the metadata a public record? And number two, you know, what type of exemptions would apply to it?
Wait. No, I don't actually think what type of exemption should apply to it is what we should look at all. I think that everyone's actually in agreement on what type of exemptions. It's the burdensome element that needs to get hashed out.
I agree with that. And I do want to thank everyone who has had this conversation with us. We really appreciate it. And I hope that in the long run, this will help all of us by answering questions now that we know are going to apply to many cases down the line.
I think to the burdensome point, I'm not saying I agree with it, but I think that this is the line of reasoning that potentially could be followed is, okay, so can it be available in the form? I think we're all saying no. It has to go through some type of, I can't just open up the calendar thing, save it, and just raw send that out, because there has to be some amount of redaction that's required to it, right?
I think the email header is a trickier one because you can, I don't know Outlook, but I can just review all my headers and then print.
Right. So I'm just looking at this file that they sent us,
Sure.
right? For the calendar, right? So everyone agreed that there's certain lines that need to be redacted.
And
okay?
you could, if you knew you were going to be doing this over and over again, you could figure out a way to
Right.
automate it.
Right.
Yes.
So I don't think that we can that the city can provide it in this format, because there needs to be some type of redaction. I can't just save it, attach an email, send it off, and say, here's the file that you wanted. Right. So it's not available. It's not, we can't just send it in this form. So there has to be some type of manipulation. So, right?
But every document that needs to be redacted requires that manipulation.
Right. The
If
question is,
I
are you
want
doing it manually or automated?
a Word document from you, from the city,
Right.
you export it as a PDF and then redact it. Like, that process is happening every time a document's redacted.
Right. I'm saying, so the second part is then, all right, so then they would have to easily generate, which I guess that would be the second point, right? And so is that then converting it to a text file and redacting it easily generated? Obviously, there's different thoughts on that.
About
Sure.
how to get that file.
Get to the microphone.
All right, yeah. So just again on how to get that TXT file. So first of all, so Anonymous said that this file is an ICS. It's not an ICS. It's a TXT if we want to be really specific. So that file doesn't just exist in Outlook in a way that you can just open it, save it as a PDF, and send it or print it and mail it to somebody. You have to open the ICS file. You have to save it to your computer. You'd have to then open it in TXT, and then you'd have to convert the TXT to a PDF so you'd be able to do the redactions, because you can't redact something in a TXT format. So those are all the steps, and that sort of goes to the point of whether it's available or easily generated.
Excuse me?
Anonymous, yes?
May I respond to that?
Sure.
The reason it says TXT when I sent it to him is because I didn't want it to, trigger a filter or something. That is an ICS file. I just renamed the file to TXT if he's talking about the one I sent it to you. Now, the fact is, both the task force and the city, I don't think, there may be some misreading of 6726. Redaction by masking is only one option that the city has. In fact, the city, by law, is allowed to just delete the parts they don't want. And they can you don't need to go to PDF. There was some discussion in 19047, and apparently it's happening now again. The law does not require them to go to PDF as a second step and then make black marks on the file. Member Wolf asked this about TXT files. How would you do it? Well, the law says they can go into that file and just delete the chunks they don't want to give me and give me the list of redactions. The law says that in 6726.
Can I respond to that?
Sure.
That's not production of the record that was requested. It's creating a new record that previously didn't exist. It's taking a file and changing the text. A redaction is to cover up the text in the file. It's still there. It's just not viewable. That's the whole point of a redaction. So I think that's just very misleading, frankly.
I think the point
I would ask you to read 6726. So.
I think the point Anonymous is making is that it does in the Sunshine Ordinance allow for masking, deleting, or otherwise segregating the non-exempt portion of a requested action.
Okay. I mean,
so the city's process may be to use a redaction system, but 6726 does, as Anonymous explained, allow for deletions and citing deletions.
yeah, I mean, I think you could do that, but I think the record you're then producing is not the actual record that was requested. It's a different record. You've erased things from it.
Well, you could say the same thing about blacking it out, and that's creating a different record.
Well, I mean, it's superimposed on it. Again, I mean, you could do a, you
Yeah.
It's
you could
fundamentally
X
the
it
same
out,
record
you could
for the
cross it out.
requester.
Anyway, I just, I don't want to go down a rabbit hole on this point, but I just don't think that's the required or most efficient way to do a redaction. And I don't think it's within the spirit of giving the actual record that was requested.
I think we should consider how we want to wrap this up, and I think we've gone back and forth quite a bit on this one. So I don't know if we want to necessarily do this with a motion, or I mean, what we basically did is we left. My understanding is we left a file open, continued it here for more information gathering.
Right.
So do we send it back to the task force as is, with some feedback? Do we want to memorialize something in a motion of sorts, or?
I mean, I would like us to send it back with focusing on those two questions that I've put forward. One is the metadata of a discrete record part of the public record, and the process of retrieving that metadata and reviewing and redacting that metadata. Does that create an overburdensome process that runs a butt against the requester's right
That
for
would
it?
somehow exempt the entire record in some way.
It runs a butt was the
Right.
best thing I could come up with,
Yeah.
yeah.
Do we want to do that as a motion, or just kind of conclude the hearing?
I
as is
think we
and-
should do it as a motion to send those two questions to the full task
Okay.
force, because that, attaches the file moving
Right,
onward, and then if the file needs to move back to this committee, then our
I think
housekeeping's
that's
in
a
order.
good-
And then,
Yeah.
is there any request involved in asking our legal counsel to weigh in on those questions, or is this really just a task force deliberation?
I mean, I believe the legal counsel looks at everything and prompts it. The legal question is what part of the Sunshine Ordinance deals with the burdensome side of work? What side does the CPRA address that, and how does any discrepancy between the two get resolved?
And I mean, and the other sort of meta question is, what do we do about the fact that the city probably does not employ enough people to do the kind of work that is continuing to be requested?
Right.
I mean, that's, yeah.
It's weird because it starts to go into that sort of pragmatic look at, which is probably outside of really our scope.
It's beyond our scope, but
it
it's a
has
consideration.
those types of
Yeah.
things too, right? I mean, like I said, we can make understand, and we could all comprehend if a department exempts, or redacts things like a social security number, right? That's something we can all understand. But like you said, to get into some of these complicated questions, it's a high level of expertise.
I mean, I don't think that it's our place to examine the city's labor to do what the public has a right
Yeah.
to.
Yeah.
Yeah.
We do not. Yeah, if the public has a right to it, it's the city's onus to figure out how to make that work. It's not our place to go, oh, well, you could hire this. No.
Right.
Right.
So the two questions are to send back to the task force, is metadata a public record, and retrieving the metadata. Amok. Okay.
I'm sorry,
So
could you
somebody
say that
making the
second part?
motion. And is retrieving the metadata, you said run amok?
No, not
No,
run
no,
amok.
no.
Burdensome. Like
Burdensome.
the whether the burdensome. It is burdensome. Whether the burdensome nature of redacting metadata
And
somehow.
we all agree that it needs to be redacted. Everyone here agrees
Yes.
that some of it needs to be redacted.
Well, the complainant and the respondent agree, which
They
means
agree.
that
Yeah.
Right.
it
yeah.
doesn't
so
matter.
I think everyone agrees that a portion of it needs to be redacted.
Right.
Okay.
So the question is how the law deals with the burdensome process of that redaction.
And was the beeping that we heard, was that an indication of anything?
That anonymous.
The call died and I reconnected.
Got it, thank you.
And do we want to do this by a vote or by acclamation? Because we're not actually making a decision on anything.
No, I think we just take it by acclamation.
Just by acclamation?
Yeah. I think that'll help steer our discussion when we get back, so it's.
Sure, and then so we have a motion that we're taking by acclamation. We don't have any members of the public, or an anonymous is a hearing party member of the a party to the hearing. Do we want to allow everyone to weigh in on the motion before we take it by acclamation?
I'm not sure anyone is necessarily part of this
A public comment.
hearing. I guess we just do a general public comment.
Well, we could
No,
do a
no.
general public comment, but nobody can participate. So I'm asking whether or not to allow the people in the room who aren't members of the public because they're members of the hearing.
I would recommend it because I appreciate everyone's
Sure.
contributions to
Sure.
this conversation.
Yeah,
So
if maybe on each side we could do, a 3-minute wrap up, or that. Maybe the city wants to go first, and then we'll let anonymous close out.
Linda Jarrell, with the Department of Technology. I just want to thank you all for your consideration. I know these are difficult subjects. It's not just paper records anymore. It is so much more complicated than that. And I hope you will hear what we're saying about trying to deliver what we need to the public, but also doing it in a way that is quality, that it's consistent, that it is accurate, and that we can ensure that it does not create a security risk for the city. And, I just appreciate you trying and looking for ways to find a common ground and to find how we can deliver service effectively in the city, because being burdensome, that's when problems happen, because people take shortcuts. And I just want you to be aware that in more than anything, burdensome in this case is probably the most important aspect and what concerns me the most, since we're dealing with security information. So thank you. Thank you. It's
Thank you.
nice to meet you all.
Okay, anonymous, did you want to wrap up with 3 minutes?
Sure. So actually, I don't just want to thank the task force. I want to thank all. I know there's a lot of high-level people from the city here. I know some of the people from the city probably are fed up with me because of all the different complicated requests I make. And thank you for processing them. I make them for a point, and that is my point of being here and doing these records quests, which is, as far as I understand, there is at least some information in what we call metadata that is a public part of a record. And the beauty of the Sunshine Ordinance, by the words of the Sunshine Ordinance, is that no document can be withheld unless every single part of that document is lawfully exempt. I completely agree with Ms. Jarrell that depending on the record, I think calendars have almost no security information. Maybe emails have a moderate amount of security information. Maybe the public health records have a lot of security information. But that argument does not allow us to say that no metadata is public. I am happy to work to suggest with the city for ways that they can automate and improve this process. But it is clear that if any part of a record is public, whether that's the single timestamp, that's the name of the camera that made the photo, whatever it is, it must be provided to the public. I urge you, please, to read the document that I have that was submitted as part of this agenda package starting on page 83. It goes against every one of their arguments. And I'm also happy to send the completely open source software that I wrote to redact EML files, ICS files, etc., to whoever in the city would like to look at it, if they are happy to, if they would like that. I know that their assumption is I'm some sort of hacker or something. I'm not. There's nothing I can do about their assumption. But I'm here to make as many records public as can be safely made public. Thank you.
Thank you. So we'll go ahead and take the motion by acclamation. Okay.
Read it back.
Sure. Why don't you do it? Yeah.
Motion made by Member Wolf to send item number 19105 back to the task force for review, and about retrieving the burdensome process of redacting information from different documents.
Sounds good.
Sounds good. Then next item.
Item number 6, adjournment. Time is 7:37.
Okay, adjourned.
Thank you.
Thank you all.
Thank you.
Thank you very
Carol.
much.
Technically, you should write the time as 7:40, or the total minutes between the two aren't going to work.
Thank you.
Okay.
Because you started with that. We started with two different. You started with one time and ended with a different.
Oh, yeah.
I know all these clocks are different, and my computer froze on me, and that's why I'm writing everything down.
I mean, I don't think anyone's going to notice.
So are we
the
off?
3 minutes.
We're off, yeah.
Not yet. I have to turn off the